Going to cover a really fun topic today in this Better FAQ video. And when I say fun, I'm being sarcastic. Because what I'm talking about today is something that we get a request for a lot from clients, which is to have a simpler, more plain English, not legalese contract for their services or their contractors or some aspect of their business. And don't get me wrong, I totally understand the desire for that. I totally understand the need for it, because confusing legalese contracts mean that you got to go to lawyers, and then there's more fees, and then nobody understands what's in them, and it can be confusing. And trust me, as an attorney, I even find some contracts confusing, so I'm right there with you. The problem, though, and the reason why we're going to push back on this whole simple plain English contract concept is something that is kind of a wonky, nerdy law thing, but very relevant to the reason why we push back, which is that the law is driven by something called case precedent. Case precedent grows out of the statutes in wherever the jurisdiction that the dispute arises. And what I mean by all of that is that we make laws. Those laws get tested in the courts. And the courts will look at contracts between parties when there's a breach of contract dispute, which at the end of the day, you have a contract in place to use breach of contract litigation as the leverage to not breach the contract and for everyone to behave appropriately and follow what that contract says. Now, when someone does breach a contract and you go to court over it, the court looks at the language of the contract. And when I say they look at the language of the contract, they go through it with a fine-tooth comb and they interpret every single word through Latin etymology to the Webster's dictionary nowadays, and they determine what those words mean in the context of the dispute, and then they determine who wins based on what the contract actually said once it's interpreted. Now, the reason that I push back and we want you to have contracts that do have legalese in them is because when we use that legalese, a court has already decided what that language means. If you don't use that language that is the common best practices in the legal industry, which totally is hard to understand, but if you don't use that language and you just use plain English, the problem that you're going to run into most likely is that a court has not actually looked at language like that before, and they have not interpreted what it means. And so when you're using plain English and there hasn't been that interpretation, you end up in these contract disputes where one side says, well, you breached, you did this, and the other side says, no, the contract says this, we didn't breach. Well, where do you look then to determine who's correct? Well, if you have language that's been interpreted by a court, your lawyer will pull a court case that says, here's how the court would decide in your jurisdiction on that language, this party's right. And then you have a definitive answer. Doesn't mean the other side's going to listen. They're going to say, well, we would win in court. We don't care what the court said, even though that's a binding legal precedent. But if you're using plain English and there's nowhere to look, you don't have a standard. And similarly, even when you use a court case and you say, this is what the court said, that does work most of the time. That should resolve the dispute because it's going to tell the other side, and if they have legal counsel as well that can look up the cases, they're going to understand that, yeah, probably if we go to court and waste a ton of money on litigation, the court's going to decide the same because there's something called stare decisis in the law, which means that you have to stick to old court decisions unless there's some kind of glaring mistake in that previous decision, in that case precedent. So when you use plain English and there's no case precedent to look at and there's no stare decisis for the court to be bound by, you're pretty much careening towards litigation, and there's really no way to know how that's going to go because plain English has not been interpreted before by the court. Maybe some of it has, and maybe you'll luck out, but for the most part, we usually push back on that request because of everything I've described here. And at the end of the day, you hire us to give you something that's going to protect you, not something that's going to cause further confusion when you guys get into a dispute and then actually cause you to go to court. And look, at the end of the day, we are not the lawyers that would go to court for you. So this isn't something where we do this because we want to see you end up in court and we're going to bill a bunch of money when you go to court. There are law firms that do that. We do not. We do this and we push back on the plain English despite the fact we understand, because we want to do our job well for you and protect you and have you rely on that case precedent. We can add in things that we call translation boxes, a little box under each provision of the agreement that says, translation, this says this. But it's really important that you do that in a certain way and that there's a provision in the agreement that says, hey, The translation boxes aren't binding, they're just to be helpful. The actual provisions that are still in legalese are the binding language. So this is why we'll push back on that. I'm sorry, I really am. I wish we could just give you an agreement that said, pay me this, I do this, sign here. It just ain't gonna protect you. Them's the breaks. Thanks for tuning in.